Hello and welcome to the Patent Agent Examination Preparation Series. My name is Priggya Arora. I am an intellectual property lawyer. Till the last video, we have discussed about patent filing, patent publication, and in this video, we'll discuss about patent examination. So we'll discuss important aspects of patent examination. And before beginning and before getting into provisions, I must tell you that this is one of the important part of the patent grant process. So do study this in detail. It has a lot of scope of objective as well as subjective questions. So let us begin with patent process like we generally do. So we have covered important aspects of patent filing, and there are four important steps in the patent grant process, which are filing, publication, examination, and grant and the post-grant process. And here we have important sections or important provisions that you need to study for patent examination. And those are to list section 11B, section 12, rule 24B, 24C, rule 2FA, 2FB, and sections 14, 15, and 18. Here we'll not go into the sections very deeply, but then I'll still suggest that you should go into details of these sections and read them once. What I'll do is I'll probably first explain why patent examination is important and what are the important aspects of patent examination. And then I'll go through some important provisions to show you that where it is written, what I have explained. So let's begin with what are the important aspects of patent examination process. So first important thing to note down here is your patent examination will not take place unless the application has been published. So the step of examination comes only after publication. It cannot happen that it comes prior to publication. Second important thing here to remember is publication happens automatically. Like if you do not file a request for publication, your patent application would be published automatically after a period of 18 months, and within 1 month, like between 18 to 19 months, it will get published automatically. But if you do not file a request for examination or expedited examination, then your patent application will not get examined. It does not happen automatically. It is mandatory to file. If you do not file, your application would be considered as withdrawn. Next, there are two types of forms associated with patent examination. One is normal examination or express examination in case of PCT applications. So don't confuse between express and expedited. Express is form 18 only, and express happens only for PCT applications. So normal examination or express examination, it happens under form 18, and expedited examination, that happens in special cases, and we'll study the grounds just now when we study the provisions. So it happens in certain special cases, and expedited examination is filed under form 18A. So there are two forms associated with it, form 18 and form 18A. 18 is for normal or express, and 18A is for expedited. Another important aspect here to remember is whenever you file for examination, a request for examination, the examiner or the controller or the patent office will give you an examination report. When you get that report, you need to file a reply within 6 months. If you do not file a reply within 6 months, then within 6 months only you have to seek extension of time under Form 4. That extension of time is available for 3 months, but it can be filed within 6 months only. It cannot be filed after expiry of 6 months. So that reply has to be given within 6 months. I think these are some important aspects of patent examination. Now we'll have a look into provisions which are important, and then you can study the provisions once yourself as well. So let us begin with section 11B, which is for request for examination. In provision 1, it is written, no application for a patent shall be examined unless the applicant or any other interested person makes a request in the prescribed manner for such examination within the prescribed period. So here certain important aspects are: who can file a request for examination? An applicant can file a request for examination, or any other interested person can file a request for examination. Now, who is any other interested person? In section 2(1)(t), we have definition of person interested, and that person interested means person who are working in the same field. So we should know that, the Patent Act has a definition of person interested, and if it has a definition of person interested, then where is the definition? It is in section 2(1)(t). Then the request has to be made in prescribed manner. If you read the associated rule, which is rule 24B and 24C, you will find out that the request can either be made under form 18 in case of examination or of application, or it can be made under 18A for expedited examination of application. So these are two rules associated with it. Then it has written within the prescribed period. Then what is the prescribed period? The prescribed period in normal cases 48 months from date of priority of the application or from date of filing of the application, whichever is early. So generally priority date is the earlier. So we say it is 48 months from date of priority. So next subsection which is important is subsection 4, which says in case the applicant or any other interested person does not make a request for examination of the application for a patent within the period as specified under subsection 1 or subsection 3, the application shall be treated as withdrawn by the applicant. So if you do not file request for examination, your application will be treated as withdrawn. Next, we have the applicant can withdraw the application even after filing request for examination. So this is the provision. And then the next provision says, in case where there is secrecy direction are imposed if your invention is related to defense purposes. So in case where there is a secrecy provision, the request for examination may be made within the prescribed period from date of revocation of secrecy provision. And what is this timeline? This timeline is of 6 months. The associated rule says the request for examination under subsection 4 of section 11B shall be made within 48 months from date of priority or from date of filing of application, or within 6 months from date of revocation of secrecy direction, whichever is later. So generally, if it is 48 months from date of priority, it is okay. But if it is not 48 months, within 48 months of date of priority, we need to check whether it is within 6 months of date of revocation of the secrecy provision. If it is within that time period, then we can file a request for examination. So let's now go to section 12. First, we'll study section 12 and then we'll study the difference between 24B and 24C. So section 12, when a request for examination has been made in respect of the application for a patent in prescribed manner or under subsection 1 or subsection 3 of 11B, the application and specification and other documents related thereto shall be transferred at the earliest by the controller to an examiner. So I'm not going into detail of section 12, but the explanation for section 12 is whenever you have whenever you file a request for examination, the request for examination goes to the controller. The controller then transmits all the documents associated with your application to the examiner. The examiner will prepare the examination report. That report will go back to the controller. The controller will review that report and then the controller will send that report to the applicant. So that is the process which happens at the patent office. And now in rules, we have the provision like once it goes to the applicant, then within 6 months, we need to file a reply. If you come to subsection 10, it will say that the time for putting an application for grant under section 21 shall be 6 months from date on which first statement of objection is issued to the applicant. That means the reply needs to be filed within 6 months of receiving the first statement of objections. So do not confuse between the terminology first examination report, FER, or first statement of objections, because our prior rules used to mention first examination report. Now the terminology is first statement of objections. But we have another subsection which is also important, which is subsection 11, and it is same in both kind of examination. So you don't have to be confused like why we are going through this provision, because these are same in 24B and 24C. So the time for putting an application in order for grant under subsection under section 21 as prescribed in sub-rule 10 may further be extended for a period of 3 months on request for extension made in form 4 along with prescribed fee made to the controller before expiry of the period specified under sub-rule 10. So this simply means that if you have not filed a reply within 6 months, you can file a reply within 9 months. That means 3 months can be extended with form 4, but form 4 has to be filed within 6 months. It cannot be filed later on. So if you need to seek an extension, you should seek it before expiry of 6 months. So these are the important provisions. Now let's come to the difference between normal examination and expedited examination. So normal examination, firstly, it is mentioned under 24B, and expedited examination is mentioned under 24C. Now, expedited examination is available for certain special circumstances only. It is not available for all the applicants. It is available only for certain special applicants. Who are these special applicants? This also you should know in detail, because there is again a scope of an objective question or a subjective question. The examiner in the examination, it may be asked that who all can file for expedited examination. And if that is the question, then you have to mention this subsection in detail. That's why you should remember who are the special entities who can apply for expedited examination. So in clause A, it is mentioned that if India has been indicated as competent international search authority or elected as an international preliminary authority in the corresponding international application. So first point is, if there is an international application and you as an applicant has chosen India as an international search authority, which is also called ISA, or International Preliminary Examination Authority, which is also called as IPEA. So if you have chosen ISA or IPEA as India in a corresponding international application, then you can apply for expedited examination. Then we have clause B, which is startup, and then we have clause C, which is small entity. So A is India is either an ISA or an IPEA in the international application. B is startup and C is small entity. So with startup and small entity, you should read rules 2FA and 2FB. So let us go through those rules as well, and let me show you what is written in those rules. Again, I would say that because this is expedited examination and we have the provision of startup and small entity who can file for expedited examination, you should know who is a small entity and who is a startup. So small entity is mentioned in section 2FA and startup is mentioned in 2FB. Now I'm not going into detail of this rule, but you should read the definition of micro, small and medium enterprise under section 7 of micro, Small and Medium Enterprise Development Act of 2006, because that is the definition which is used for patents. Then we have startup. The definition of startup is also important because it has been amended, I think, 2 or 3 times. That's why it is important for the purpose of examination. And recently, there are a lot of notifications which are coming related to Startup India schemes, so which is also called SIPP schemes. So I think you should go through the definition of startup and small entity also. And in startup, it is written that the definition of startup would be adopted from the Startup India initiative. You just open the website of Startup India initiative and read what is called as a startup, because that same definition is applicable for patents as well. And then you need to remember that initially there was no provision for foreign entities being recognized as startup for the purpose of patent filing. But now we have this clause that in case of a foreign entity, an entity fulfilling the criteria of turnover and period of incorporation of registration as per Startup India initiative and submitting declaration to that effect. If a person is satisfying that, even if it is a foreign entity, they can also be claimed as startup, and they can also take benefit of expedited examination. So do go through these definitions also once. And now we'll go back to the who can be considered for filing expedited examination. So yes, in clause A, it was written that if you have chosen India as ISA or IPEA in the international application, then you can file for expedited examination. Next, we have if applicant is a startup, he can file for expedited examination. Then if applicant is a small entity, then they can file for request for expedited examination. Then we have clause D, which says if there are several applicants, then at least one applicant is a female applicant. So if it is a single applicant, then if it is a female applicant, they can claim benefit of expedited examination. Or if in case of joint applicants, at least one of the applicants should be a female, then only they can expedite the examination process. Now, you have to be careful here that it is written applicant is a female. It is not written that inventor is a female. So even if an inventor is a female, this provision is not applicable. This is only applicable if applicant, at least one of the applicants is a female. Next, clause E, F, G, H, and I. These are related to government entities. So you should go through these clauses individually, but it will have things like applicant is a department of government. Applicant is an institution established by the government and controlled by the government. The applicant is a company which is financed by the government. So all these clauses are related to applicants are associated with the government. Then we have next important clause, which is clause J, and it says that the applicant is eligible under an arrangement for processing a patent application pursuant to an agreement between Indian Patent Office and a foreign patent office. And it has an explanation also which says the patentability of patent application filed under clause J above will be in accordance with the provisions of this act. So this means, for example, India has an association with a country XYZ. So if India has an association with that country and they have certain arrangement with them that if a patent is granted in country XYZ, Indian Patent Office will use examination report of that country or grant a patent based on these clauses. So if we have certain foreign arrangements, then this provision can be applicable, and they have clarified that patentability of the application would be checked in accordance with the Indian Patent Act as well. So even if the patent is granted in other country, they'll see whether we are complying with Indian Patent Act or not. But it can an expedited examination request can be filed based on a foreign country if we have an arrangement with that country. So these are some important grounds on which we can expedite the examination. It can be filed in Form 18A, and you should be aware and you should learn these grounds very much because these are important. And now I'll go through some important aspects of examination which you should know because examination is an important step. So for example, there is a startup at the time of filing of the request, and you have filed the request as a startup during that time, but actual examination is taking place after 2 or 3 years, and at that time the turnover of that company is increased, and now that company ceases to be a startup and has been converted into a large entity. So because these situations might be prevalent, the government says, or the act says, that in that case, the request for expedited examination would be valid and it would not be seized. For that, we have a provision, which is clause 5, which is a startup or small entity shall not be questioned merely on the ground that startup or small entity having filed an application for a patent ceases to be a startup or small entity due to lapse of the period during which it is recognized by the competent authority, or its turnover subsequently crosses the financial threshold limit as notified by the competent authority. So if in case this happened, then also your request for expedited examination would be valid. Then, for example, you are applicable for expedited examination, but you wanted to save certain fee and you filed a normal examination. But at a later stage, probably after 1 year, you think that no, I want to file as an expedited examination. Then you can pay difference of fee and apply for an expedited examination, provided you have some ground under subsection 1. So if you are fulfilling any ground, you are a female applicant, or you have chosen ISA or IPA in the international application as India, or you are a startup or a small entity. So if any of the ground is applicable, then after paying difference of fee, you can file for expedited examination. So it is written, a request for examination filed under Rule 24B may be converted to expedited examination under Sub-Rule 1 or 24C by paying relevant fee and submitting requisite documents under Sub-Rule 1. A request for publication is also important, otherwise your application will not get examined early. So it is written in this sub-rule that except where the application has already been published under Sub-Rule 2 of Section 11A, or request for publication under Rule 24A has been filed, a request for expedited examination shall be accompanied by a request for publication under Rule 24A. So if examination has not happened, then if you are filing for expedited examination, you should file for request for publication as well. Now, what is explained in clause 4? It is explained, for example, you did not have any ground for filing request for expedited examination, but you filed request for expedited examination. In that case, if you are not complying with requirements of 24C, the patent office will consider as if you have filed a normal examination and your application would be processed accordingly. Now, there are some other timelines which are mentioned in 24B and 24C. I'll suggest give it a read, because like in section 12, it is explained the controller will give the examination, give the documents to the examiner. The examiner will prepare the examination report and give back to the controller. The controller will review and give it to the applicant. So in both these sections, you will find timelines, like within what timeline examiner should give the report to the controller, within what time the controller should give the report to the applicant. So all of these timelines are mentioned in 24B and 24C as well. And these unfair reading of this will tell you that 24C timelines are shorter than 24B timelines, because 24C is an expedited examination. So I think that is also important, but because it happens at the side of patent office and the applicant cannot do much about it. You can go through it once, but yeah, other provisions of examination are very, very important. So those timelines and those sections you should remember. This you can give it a read once so that if an objective question comes, a timeline clicks to you so you can answer. So these were important aspects of patent examination. These are the sections. I'll say once more so that you can open the provision and read them. One, section 11B, section 12, 24, rule 24B, 24C, rule 2FA, 2FB, and section 14, 15, and 18. 14, 15, and 18 are related to powers of the controller, what all things the controller can do during examination. So do go through those section once. And I think this was all about examination. Examination is also read with the provisions of anticipation. So probably in the next session, we'll study what is anticipation and what are important sections related to anticipation. So that's all for today. Thank you.